So I think my head just exploded. I think it just went just Friday. My head is still about to explode from a Wednesday morning meeting that I had regarding. Is that it for you, Council? Or?
No, Judge, I have one more. This is going to make my head explode. Good afternoon, Your Honor. Jim McCarl on behalf of Beal Properties.
Judge Dominic Camden appearing on behalf of Melissa Deal.
All right. Are you appearing on behalf of Hardman?
Those are children, Judge.
Those are children. Gotcha. All right. Where are we on this?
Your
No,
counsel. Judge, there was a consent order that was issued maybe a month and a half ago. Client filed paperwork at my office initially indicating that she was having some medical issues. I appeared
regarding the move out.
Plaintiff's counsel understandably was not there because I don't think my client served them, so I'm not taking any issue with that at all. Subsequent to that, the plaintiff's counsel filed the actual writ to evict my client, and the court set it for hearing today. I can tell the court that I got notification from my client of today's hearing. I didn't come directly from the courthouse, which, okay. But my client did inform me that she's having a heart procedure. This started at about, she had to be at the hospital at 7 a.m. And I did not, she basically had told me she had been waiting for the appointment, and there was an appointment that opened, and I instructed my client that she needed to keep her appointment because, with all due respect to this court, her health took precedence, and I'll fill the gap in the floor. But her procedure was today.
Okay.
Right away, the judge is balancing two competing realities. On one hand, a tenant has a serious medical procedure. On the other, there's already a court order requiring the property to be vacated. Courts often have to weigh compassion against enforcing existing orders, and that's rarely an easy decision. What would you prioritize if you were the judge?
Well, Your Honor, insofar as the appearance here, I certainly have no truck with that. But there was an order that said that the defendants were going to vacate by April 1st. They did not. That order was entered in February. They had a month and a half to effectuate what they were supposed to do, and they continue to occupy the property. My client understandably wants possession of the property, and that's why we're here today.
Do we have any verification that this procedure is taking place?
I have an email, Judge,
from her. But nothing.
I did not ask for any verification from the doctor's office, Judge.
Is no rent is being paid, right?
Correct. She was a Section 8.
Section 8 been terminated?
It has been terminated, Your Honor. I'm just told by my client that the debt is up to $50,000 at this point. Yes, Your Honor.
I mean, we're going to get into, maybe we need to get into, but there's some question about whether it was terminated correctly, who was necessarily caused it to basically be lapsed, which was the basis for the counter complaint that was filed in this case. Actually, the reason why the parties agreed to dismiss it without prejudice.
So you're indicating you want to raise the initial issues that were subject to the dismissal.
If we could approach.
Yeah. All right, record investigation down for case. This is regarding the issuance of the writ in this matter. Mr. Hampton was gracious enough to share with myself and counsel the email that was sent. The nature, I don't know the entire nature of the procedure that the defendant is undergoing. However, one thing that is stated in there that gives shed some light for the court is that she indicates to be available next week. I'm not going to adjourn it to next week because I don't know that there's really an issue ultimately that this court is going to come to. So I'm going to issue the writ, but delay its execution and indicate that it can be executed.
This is an important legal
early.
distinction. The judge is granting additional time, but he's also making it crystal clear that this is not an open-ended delay. By setting a firm execution date, the court gives the tenant one final opportunity while also protecting the landlord's right to regain possession. It's a reminder that deadlines in court aren't suggestions. They carry real legal consequences.
Than the 29th. All right. So that way she's got to the end of the month and she's done. Counsel posed a good question that is to trying to make sure that it's final. I wish a lot of things in my life were final. If somebody comes in and says something, I think I'm obligated to listen, but the intent of the court in doing this is that this is it. It's done. One or two ways it's going to happen at the end of this month. Right?
Thank you, Judge.
All right. Thank you. When we locate it, I had to just put on there.
Not prior to the 20th.
Yeah, not to be exit forever. Real Properties versus Lieutenant Patrick. Real Properties versus Lieutenant Patrick. Are these?
I'll get another William Farm on behalf of Beal Properties.
The first two are got it. Your name? Simple. Your name, sir? All right. Well, where are we in this case?
Your Honor, the rent to retain is $2,982.32 with costs of $176.32 for a total of $3,162.64. We're asking for a writ date of May 18th.
All right. Anybody? Yes. Your position with this is you can restate it for the record. Your position with this case? Yes. Okay. So what were you going to tell me?
So there's correspondence with the actual homeowner that there's an agreement where we would continue to pay the rent that we've been paying. In addition to the utility bills that I do utility amounts for, which were done on yesterday, as a matter of fact. And then we would continue to seek alternate funding for the back rent, as well as find Mr. Matata a new unit to go to. And then my agency could then, if we couldn't seek an alternate community resource to pay for his back rent or pay a portion of that, we could then pay that entire back rent at that point once he leaves the unit. And that's in correspondence. There's an entire email thread with that the previous attorney should have access to. The one that was here a week ago.
All right. So
That's all I believe anymore.
yeah. So what's really happening is the rent's going to be paid going forward.
It has been for the last 2 months. We've paid 2 payments already of $17.60, plus have done 2 utility allowances for Mr. Matata as well.
So what months would those be?
It was March, and, sorry, it was April, and then I just delivered one. Yes, Wednesday, maybe Tuesday, Wednesday. It was a little late because our printing machine was down. I delivered it to the new address on Michigan Avenue in the Dropbox.
So that payment must not have been taken off of this account. And the only reason, okay, the only reason I'm saying that is because the number claimed owed went up 1 month. But if what you're indicating happened, then it's going to go back to that one figure where I have a static amount of back rent. Okay.
Correct.
All right. No, that's okay. So what are we gonna do then on the case? I get that rent's being paid going forward, but I don't know.
I'm not sure. I assumed there was correspondence with them. He had agreed. He said put it in letterhead, which I attached to the email as he suggested with the terms. So I'm not exactly sure.
But go ahead, Ken.
Your Honor, my client has indicated that what he is willing to accept as a conditional dismissal with the terms that have been laid out before the court.
Okay, I guess I don't have a problem with it, but I don't want to end up as the one thing that I didn't hear. Is there a date that he's going to move, or has that been resolved?
For alternate housing right now.
Okay, that's going to be right. No, I get it. I guess that's going to be my problem with the conditional dismissal because there isn't an end.
Well,
Oh,
I would raise the question then: is there a reasonable expectation he'd be out by the end of June? Because we put it at the end of June date in there. If not, then we're back to the question you posed, Your Honor.
Yeah, but I don't know if that's realistic under. I mean, I can't force somebody to agree to that date. It sounds to me like the parties are working together so that everything stays static. The one thing that's missing is that end date. And how many people are in his family? You know, is it just him?
So
Okay, that's going to be okay. Now I understand. That's going to be the problem because you got to find a unit for 7.
and the family has no income, so that's been the issue, accumulating late fees, and there have been some fees that have been attached that our grant could not cover. So I've had to find for the last several years, we've been working with him, community resources to cover these fees. And at this point, we've just ran out of funding for those resources.
This
In a big
hearing has
way.
shifted from a
So-
simple eviction into something much bigger, a housing stability problem. With emergency assistance drying up and a family of 7 needing suitable
Let me
housing,
ask this:
the judge isn't just looking
If
at unpaid rent.
the
He's
back
trying to find a
balance got
solution that
paid,
follows the law while
are they gonna be able
recognizing
to
the human impact
stay
behind the
or
case.
no?
These are the
Is that- I
moments
mean-
where courtroom
Our client
decisions
indicates yes,
become
Judge.
far more
Okay.
complicated than they first appear.
He's accessed the ESG funding through SOS several weeks ago, which was the max at that point. And so we've met that for the year already.
So he's already gone through SOS, got the 3.
My agency, though, I was confirmed with my supervisor on Thursday. We're getting some additional funding for housing in June. What that looks like, I'm not entirely sure. We could put some of that funding towards that balance if that's
This is coming from the county.
no, sir. I'm not sure what the funding is. If it's
Okay,
grant or
gotcha. Okay, no, the other reason I'm asking is because everything is now messed up with funding
yeah.
in a big way. So let me ask this: if the back balance got paid, are they going to be able to stay or no? I mean,
Our client indicates yes, Judge.
okay.
My grant, unfortunately, we can't pay that back rent until he's out of the unit.
Because nobody wants to make my life easy. Okay.
And it's my fault.
Client indicates, Judge, if the court is comfortable with putting either a July or an August date to give them more time, we could put that in the conditional dismissal if the court is comfortable with it.
I'd be comfortable with this because We could do that so that there's a conditional dismissal of August, but that there would be no rent without a hearing.